Okay, so in the last class we had done up to chapter 15, and today we'll start from chapter 16. Okay, chapter 16 is offense relating to human body from 299 to 377. So if you cause any offense with related to human life, 299 to 311, offense related to miscarriage, 312 to 316, then hurt, grievous hurt, 319 to 338, wrongful restraint and confinement, 339 to 348, force assault, 349 to 358, kidnapping, abduction, 359 to 374, rape, 375 to 376E, and unnatural sex is 377. Okay, now murder and culpable homicide will study under these following heads. Okay, so let's start from 299. 299 says 299 covers basically three things. That is, first, intention to cause death with bodily injury, and without bodily injury. First is intention to cause death with bodily injury or without bodily injury. Second is intention to cause such bodily injury as is likely to cause death. And third is did act with the knowledge of likelihood of causing death. Here there is no intention but knowledge that in all likelihood it may cause death. Okay, so intention to cause death, intention to cause such bodily injury as is likely to cause death, and doing an act with the knowledge of likelihood of causing death. These are three things covered under section 299. Okay, now culpable homicide is genus and murder is species. You have to remember that yes, culpable homicide is killing of a human being, but when that is added with certain, homicide is killing of a human being, culpable homicide means when you can give culpability to the homicide, that means you can fix accountability for that killing of the human being, and that is murder when there is some extra element we'll now discuss. Okay, 299 1 says whoever causes death by doing an act with intention of causing death, that means death. Here there is an act that is doing an act, and there is an intention to cause death. 301 in fact says the same thing, that is, if the act by which death is caused is done with the intention of causing death, then that is 301. Now 299 2 and 302, what is the difference? 299 2 is intention to cause bodily injury as is likely to cause death, and 302 is intention to cause such bodily injury as offender knows is likely to cause death. So here it is, knowledge that death will be caused cannot be presumed here in 299 2, but in 302 knowledge is additionally imputed. He has specific knowledge that yes, offender knows that it is likely to cause death. Okay, example, yes, suppose A had a swollen spleen and B is aware of his condition, so here he gives two fist blows on his abdomen and it causes the spleen to burst. Okay, so yes, he knows that such bodily injury is likely to cause death, and with the intention to cause such bodily injury he has done that, so that will be under 2 302. And then yes, so the knowledge of peculiar condition is required here. Now again 299 3 is knowledge that he is likely by such act to cause death. Knowledge that he is likely by such act to cause death. What it is, that means imagine A, what does he do? He throws B from terrace with the knowledge that he by thereby several body parts will be broken. He doesn't know as specifically which body part will be broken, but yes, there is a possibility that there will be certain injuries which is likely to cause death. 300 clause 3 similarly says that yes, there is, if to here there is a element of bodily injury which is sufficient in the ordinary course of nature to cause death. So here intention to cause bodily injury is there, and bodily, yes, someone is saying something. अरे म्यूट करो, ये सही है, शिवशंकर म्यूट करो. हाँ, 303 intention to cause bodily injury, and bodily injury is likely to cause death, and bodily
Sorry, sir.
injury.
Land not sir.
Okay, no issues.
On mute.
Huh, it's okay. So intention to cause bodily injury is likely to cause death, and bodily injury is sufficient in the ordinary course of nature to cause death. 303 re asibo. So 299 3 out 303 re. This is the difference. Okay. So objective examination by doctor darkar 299 2 re jodi likely to cause death and sufficient to cause death jodi tale 303 re padibo. Okay, and subjective examination भी करेगा पड़ेगा accused intention को कि mind needs to be examined as that of a prudent person. Now 304 तादरे कौन कहला 304 रे कहला person committing the act knows that it is imminently dangerous and must in all probability cause death. So here what is he doing? He knows that the act that he is doing is so imminently dangerous that in all probability it is likely to cause death, or it is inflicting a bodily injury which is likely to cause death, and commits the same without any excuse. Then in that case it will be section 300 clause 4. Okay, so people standing at railway station, he has a small bomb, throws it at the crowd, one person dies, that is 304. Now without a reasonable excuse is important here. So without reasonable excuse in fact refers to the circumstances surrounding the incident. Okay, doesn't refer to the general exceptions, exceptions or the 5 exceptions given under 300. Rather it gives to the circumstances surrounding the incident where he is incurring a reasonable excuse. So court will now evaluate the excuse. Of course there is no formula here. Now culpable homicide amounting to murder and not amounting to murder. Murder of intended person is 302. Now transfer of malice 301 will discuss. 303 is, of course, it's not constitutional anymore. It has been declared unconstitutional. Now not amounting to murder, if it is with intention to cause death, that is 3041, and if with the knowledge that it is likely to cause death, then it is 3042. 3042. Okay. Now the explanations of 299, 3 things we studied. That the explanations are, first, it is if it is causing such bodily injury, that means it includes without bodily injury as well. If it is under a disease and it accelerates death, then that is also included under bodily injury. Okay, so A is suffering from cancer, B stabbed him to death. Here it will be murder, because here he is accelerating the death. You can't say that anyway he would have died from death and from cancer, so he will not be subjected to that. Yes, he will still be subject to that. Now explanation 2 is, it says if causes bodily injury by resorting to proper treatment, death could be prevented. He says that I have caused a bodily injury, but if you had resorted to proper treatment, then death could have been prevented. Still it would not be a valid defense, because it would still be coming for murder, because suppose A stabbed B and B is lying on the floor and C picks him up and he drops him several times and the knife went in. Now he here A would be still liable for murder. A would be still liable for murder. Okay. Now cause is the sine qua non. Here in fact you have to remember that which cause initiated the entire transaction. Okay, and causa causes, that is immediate and effective cause, that these two things has to be not done. That suppose I am causing a bodily injury, that is initiating the transaction, but now if I am giving an immediate cause, I am immediate cause, and then that is also coming under this explanation to section 299. Now expression 3 says if there is a child in the mother's womb and you are causing a death, then that would not be homicide. But if child is delivered and in the process what happens, that means some part of the body has come out, even though he has not breathed completely, some part of the body has come out, still then if there is any act done and the child dies, that can be coming under culpable homicide. Okay. Now coming to miscarriage. Miscarriage is 312 with consent of wife. If wife herself causes miscarriage, Then if it is quick with child, then 7 years. Not quick with child is 3 years. Can you tell me what do you understand by quick with child? Anyone? What is quick with child? No one. What do you understand by quick with child?
So, before 9 months or 280 days, if the child is born, then it is called quick child.
In fact, quick with child is when the movement of the fetus is felt. Okay, so it's the advanced stage of pregnancy. Then it will be 7 years. Okay, but 3 years is initial days of pregnancy where the movement of the fetus is not felt as such. That is 3 years. Okay, quick with child is when you feel the fetus movement and then the miscarriage is caused. Then in that case, it would be 3 12 quick with child 7 years, and if it is not quick with child, then 3 years. Now 313 is without consent of the wife. If it is done, then life imprisonment and 10 years. And 314 is if there is a mens rea to cause miscarriage, an act done, and the result is that it is death of the woman, but there was no mens rea towards the woman. You wanted to cause miscarriage, but what happened? That in the process the woman dies. Then it will be 10 years. Next, there is mens rea to cause death of the woman, but you had no mens rea to cause death of the child, but the child dies. Then in that case, it will be 10 years. It will be 10 years. Next, 315, if act done before the birth of child and during pregnancy, child born fragile, or if it is preventing to be born, and the effect is that the child dies during delivery or after delivery, then in that case the punishment would be 10 years. 317 is if you abandon the child below 12 years by parent and the mens rea is to abandon the child, then that will be 7 years of fine or both. And 318 is concealment of birth by secret disposal of body, or secretly burying or disposing dead body of child. That is 2 years or fine or both. Okay. Now let's come into the further discussions. That is, yes, suppose suppose circumstances, we'll discuss that. Now imagine A has punched B and now B is unconscious, and believing that B is dead, after reasonable examination he hangs him. Okay, he hangs him thinking him to be dead. So whether he should be liable for the murder? No. The post-mortem report, if it says that the death is because of the strangulation and not because of the punching, then in that case he will not be liable for murder, because the mens rea will be attributed as that of the original act. Okay, of the mens rea will not be attributed that he did not he he strangulated him, because he punched him and knowing that, thinking that he is dead, he hanged him. Here he will not be guilty of this particular thing. Now transfer of malice also will discuss. Transfer of malice is suppose A shoots B and B ducks, and the bullet goes and hits C and C dies. Whether now A will be liable for murder of C? Yes, A will be liable for murder of C, because if you have a malice towards a particular person, and in that process that malice is reflected on someone else, then under the doctrine of transfer of malice you would be held liable. If someone else also dies, you would still be held liable. Okay. Now, yes, you may be liable for attempt of murder of B, but you'll be liable for murder of C. Okay, and let's take the example of Emperor Murthy versus Mushnuru Surya Narayan. Here, what happened? Suppose A, what did he do? A mixed poison with a halwa and gave to B with the intention of killing B. Now B gives it to his daughter. He doesn't eat and gives it to his daughter. Now the child dies. So A would here be liable for attempt of murder of B, but murder of the C, that is the child. Okay. So that is doctrine of transfer of malice. Now let's study the exceptions to the section 300. 5 P's are the exceptions. First is grave and sudden provocation, private defense, P, act of public servant, third P, sudden heat and of passion, fourth P, permission, permission or own consent, that is the fifth P. Okay. Now, but provocation doesn't mean that you will be self-provoking yourself and do it. No. Second, if a public servant uh, uses its lawful power, then you can't take this exception of provocation. And provoked when someone is acting under the right of private defense, that will not be also coming under the exception. Otherwise, if there is provocation, then it can come under one of the exceptions. Okay. Now came Nanavati and R versus Ahluwalia. These are important cases that you'll study. Along with that, R versus Govinda is very, very important. You please go through in order to understand the difference between 219 and 300. Of course, we could have discussed if we had more time. Palani Gondan versus Emperor is 299 300. Emperor versus Musunu Satyanarayan Murthy 301. Then Rawal Penta Bhankalu versus District of Hyderabad 301. Visa Singh versus State of Punjab 303. State of Andhra Pradesh versus R. Punnaya 299B and 303. And Supadi Lukada versus Emperor 300 clause 4. You please see all these cases. Emperor versus MT Dhiraraja 300 clause 4. Girsabai versus State 304. Kem Nanavati versus State of Maharashtra, very, very important. R versus Duffy 300 exception 1. Ghappu Yadav versus State of MP exception 4 to section 300. And Cherubin Gregory versus State of Bihar is 304A. Okay. Now Shanti versus Haryana is 304B. Harjit Singh versus Punjab is 304B. Mittu Singh versus State of Punjab 303 declared unconstitutional, very, very important. Dukhi Singh versus State exception 3 to 300. Jacob Mathew versus State of Punjab 304A, very, very important again. SN Hussain versus State of MP. And Cherubin Gregory versus State of Bihar, that is again, all of these are 304A, very, very important. Okay, so now 304A is causing death by negligence. So if someone is causing death by doing rash or negligent act and it is not amounting to culpable homicide, then in that case it would come under causing death by negligence. Okay, suppose imagine that yes, I am fixing electric wire in my land, and what happens, someone touches that electric wire, I have not fixed any warning, now someone touches that wire and dies, I will be held liable for the rash and negligent act and causing death. Okay, Cherubin Gregory versus State of Bihar is the exact case where people were coming to use the toilet and owner complained, but when no one listened, owner put live wire without warning or without notice. Now someone entered and got electrified, it was held liable under a rash and negligent act. Okay. Now, yes, doctors can also be held liable under this if they are in two things. If they are not skilled for particular treatment and still undertook the treatment, then they can be liable. Or if skilled for that treatment but manifestly wrong treatment, which no reasonable doctor would have done. Like I had given an example that suppose a doctor, what did he do? He should have performed an operation on right leg, but he performed operation on the left leg. Now this is manifestly wrong procedure. Here he can be held liable for gross negligence, and here he can be held liable. Now Jacob Mathew versus State of Punjab is the very, very important case. Suresh Gupta versus Government of NCT of Delhi, and there are two tests here as well. That is two tests here as well. One is Bolam test and another is Bolitho test. Okay, Bolam test and Bolitho test. If you have time, you may refer it. Prelims, it may simply be asked which Bolam test refers to which section of IPC. Then you may write 304A. Okay, Bolam test or Bolitho test. Now 304B is dowry death. Dowry death is if there is a death of the woman caused by the burn, bodily injury, or otherwise than in normal circumstances within 7 years of marriage, and it is shown that soon before her death she was subjected to cruelty or harassment by the husband, relative of the husband, for dowry, then in that case the punishment which can be given is 7 years to life imprisonment. 7 years to life imprisonment it can be given. Okay. Now, abatement of suicide, if it is done of a child below 18 years, idiot, unsound mind, or delirious person, or intoxicated person, then death, life imprisonment, 10 years plus fine. But if it is done of any normal person, then he can be liable under 306. 306, punishment is 10 years plus fine. Punishment is 10 years plus fine. Okay, next is attempt to murder. If is done and death is caused, then 10 years, and hurt is caused, then life imprisonment plus 10 years. An attempt by life convicts, then the conviction would, then the if there is a conviction, the punishment would be death. 308, attempt to culpable homicide. If death is caused, 3 years. If not, if hurt is caused, then it would be, so sorry, if death is caused, it's 7 years. If hurt is caused, it's 3 years. Ulta likha hai. And 309 says if attempt to commit suicide, so someone has attempted to commit suicide, then simple imprisonment of 1 year will be given. Okay, now 310. 310 is if a thug habitually associated for the purpose of committing robbery or child stealing, and he is accompanied by murder, he's doing it, then the punishment given will be life imprisonment and fine. Now, coming to hurt and grievous hurt. Hurt, if someone is causing bodily pain, disease, or infirmity on someone, then that is hurt. And grievous hurt would be under this particular circumstances, 8 circumstances. If there is emasculation, if there is permanent privation of eye, permanent privation of ear, permanent privation of joint, fracture, dislocation of bone or tooth, okay, or destruction, permanent impairing of powers of joint, or disfiguration of head, or disfiguration of face, or any hurt for more than 20 days, then that would be what? That would be under 320, that is grievous hurt. 320, that is grievous hurt. 321, if voluntarily causing hurt, then 321, and punishment given is 1 year or fine under 323. 322 is voluntarily causing grievous hurt, and the fine given is the punishment given is uh, uh, life imprisonment, 10 years, or sorry, punishment given is 7 years plus fine in 325, and in 326, if voluntarily causing hurt by dangerous weapon or means, then life imprisonment, 10 years, or fine will be given. Okay, now voluntarily causing hurt by dangerous weapon or means, then 3 years plus fine or both is also there under 324. Now 326A, voluntarily causing grievous hurt by use of acid. So if you are causing any damage, deformity, burn, maiming, disfiguring, disabling any part of the body, or grievous hurt, how? By throwing acid, administering acid, or using any other means, then what can be given is maximum is life imprisonment, minimum is 10 years plus fine. Okay, section 326B is voluntarily throwing or attempting to throw acid. If you throw acid, administer acid, or use of other means or attempt, then if it is to cause hurt or grievous hurt, then maximum 7 years to 5 years plus fine can be given. If it is done, then that can be given. Now, if you are voluntarily causing hurt, and in order to extort property or to make them do illegal act, then in that case you will be liable under 327. But voluntarily causing grievous hurt to extort property or make them do illegal act, that will be 329. Now 329 is causing hurt by poison or intoxicating drug, that will be 328. And 330 is voluntarily causing hurt to compel restoration of property or to extract confession, that is 330. 331 is voluntarily causing grievous hurt, that is in order to compel restoration of property or extract confession, then that is 331, he will be liable. Now 332 is voluntarily causing hurt to deter public servant from duty. 330 is voluntarily causing grievous hurt to deter public servant from duty. 334 is voluntarily causing hurt on provocation, and 335 is voluntarily causing grievous hurt on provocation. 336 is act of endangering life or personal safety of others by a rash and negligent act. 337 is you are causing hurt by doing an act of which is rash and negligent or to endanger human life. Now 338 is again causing the same with rash and negligent act to endanger human life, that is 338. 8. 339 is wrongful restraint and wrongful confinement. Now, wrongful restraint is obstruction from going in a direction which the victim has a right to go, and here you are just preventing someone to go in one particular direction. But in the wrongful confinement, obstruction from going in any direction, that is all direction, you are confining him. And then if it is done voluntarily, that is intentionally or with knowledge or reason to believe, then in that case it will be a voluntary restraint or confinement, as the case may be. Punishment for voluntary wrongful restraint is 1 month or fine or both, and punishment for wrongful confinement is 1 year or fine or both. Okay. Now, 343 is wrongful confinement if it is done for 3 or more days, then 343, and if it is done for 10 or more days, then 344. 345 is wrongful confinement if there is a writ issued for liberation, that is habeas corpus writ is done, and now order is issued that he should be produced, but still you are wrongfully confinement, then 345 you will be liable. And 346 is if wrongful confinement is done in secret, then that is 346. And in wrongful confinement is done to extract property or to consider to do an illegal act, then that would be 347. And wrongful confinement in order to extract confession or to compel restoration of property, that would be 348. Okay. Now 349 is force if you are causing motion, change in motion or cessation of motion for a person or substance. You are bringing him into contact with others body, or um, anything or anything, or affect the sense of feeling, then in that case it is done either by own body or by substance or by inducing any animal, then that will be force. So basically you are using any force on someone, that will be coming under 349. And when it is done that means when use of force is done without consent, in order to either commit offense or to cause bodily injury or to cause fear or annoyance, then that is called criminal force. Assault is when you are making any gesture and causing the person to apprehend that you are about to use any criminal force. So that means I'm not exactly hitting, but I'm just showing a gesture that I might hit. That is 351. 352 says assault or criminal force otherwise than on grave provocation, that will be 3 months of fine or both. Okay. And 353 is if you are causing assault or criminal force in order to deter the public servant from discharging the duty, in that case it would be 353. 354 is if assault or criminal force to woman with the intention that her modesty would be outraged, or knowledge that her modesty would be outraged, pulling the sari of a woman or anything, then it would be again punished for 1 to 5 years, and fine is also prescribed. Now 354A, if you're causing a sexual harassment, that is either by physical contact, which is advances and unwelcome explicit sexual overtures, or demand or request for sexual favors, or showing pornography against the will of the woman, or making sexually colored remarks. All of these if you are doing, then there is punishment under 354A. For the first three categories, 3 years or fine or both, and for the fourth category it is 1 year or fine or both. Okay. Now 354B, assault or criminal force to disrobe woman. If you are assaulting or using criminal force to woman or abetting it, and in order to disrobe her or compelling her to be naked, then in that case there will be punishment. Minimum is 3 years, maximum is 7 years. Along with that, fine is also there. Now 354C, voyeurism. Voyeurism, what does it say? If any man or disseminates, that means spreads, what image of woman who is engaging in a private act and who is expecting not to be observed. That means whether she is taking a shower, whether she's using the washroom, or using or indulging in sexual act, then in that case, if you are engaging, if you are watching that or capturing that or disseminate that, then that will be voyeurism. Okay, whereby victim's genitals, posterior or breasts are exposed, or but he is still being contacted, followed, etc. Or he is monitoring the use of e-communication by women. He is monitoring the use of e-communication by women. Okay, so what is done, that either who is trying to join? Okay, so yes, monitors the use of e-communication by women. Then in that case, in these cases, first conviction 3 years of fine, subsequent conviction is again 5 years plus fine. Exception is if for preventing or detecting crime authorized by state, if you are doing it, then you will not be liable. In compliance of law, then you will not be liable. And reasonable and justified conduct of accused in particular circumstances, then you will not be liable. Otherwise, you would be liable for stalking. Okay, 354D. Now 359. Now let's come to 359, that is kidnapping. Kidnapping from India and kidnapping from lawful guardianship. Kidnapping from India, 360, what does it say? If anyone conveys any person from India, then conveys means to transfer either through own or through agent from India, that is without consent. Without consent is if someone is being transported, that he from him consent will be given, or if it is a minor, then consent of the guardian is taken. Or if without taking this he's transported, or um, he's conveyed beyond the limits of India, then in that case it will be kidnapping from India. Okay. Now the transportation can be done either by deceit or force, either um, for defrauding him or forcefully it can be taken. Now kidnapping from lawful guardianship, this is subject to particular age only. So here you are taking or enticing a male of below 16 years and female of below 18 years, male below 16 years and female below 18 years, or unsound mind person, and you are keeping him guardian out of the guardian without the consent that is implied or expressed. And what is the purpose? Either for sorry then if you're doing it, then in that case it will be what kidnapping from lawful guardianship. Okay, but yes, if you are doing it for social welfare or protection of child of unsound, or protecting the rights of lawful guardian, then in that case different. So exception is that if in good faith believing to be the father, if he is taken, then it will not be done. Okay, now strict liability is given here, and 363 is punishment prescribing, which is saying 7 years plus fine. Okay, now yes, these are the famous cases, R versus Prince being the major one. Now abduction is 362 if it is done by force or by deceitful means. That is to go from one place, and it can be a major, minor, unsound, doesn't matter. Then in that case, if it is done for a certain purpose, then in that case abduction per se is not punishable. Abduction should be done for a particular purpose, then it can be punishable. Gurucharan versus state. Kidnapping, here you did not check any purpose. Kidnapping from India, kidnapping from lawful guardianship itself is punishable. But abduction, yes, the purpose needs to be checked. Kidnapping is one time, but abduction is continuing. Okay. Now, yes, here person is liable, but here person is as such not liable if it is there is no purpose. Okay. Now, what are the special purposes? If kidnapping or if abduction is for kidnapping or maiming a minor, or for using or begging, minor is male 16, female below 18, then that can be under 363A. Now 364 is kidnapping or abducting in order to murder. Now 364A is kidnapping for ransom. 365 is wrongful confinement के लिए kidnapping or abduction. Read with 368. Now 369 is stealing anything from body, and that's why you are abducting. Now 366 is to compel marriage, that's why you are abducting. Now 366A is procuring minor girl or less than 18 year, you are abducting. 362 is importing girl. 367 is cause grievous hurt or slavery or to satisfy unnatural lust is abducted, then it is under 367. As I told you, abduction should be done for a particular purpose, then only it can be punished. Now section 370 is trafficking. Whoever for the purpose of exploitation of persons, exploitation can be either physical, sexual, any form of removal of organs, or for engaging in slavery. Here consent is immaterial, and if he is taken, what is done? Either he is recruited, transported, harbored, all of that is done, and this is done either by force threat, force, coercion, abduction, fraud, deception, or abuse of power or inducement. Then this would be called trafficking. Okay. Now 370 is exploitation of trafficked person, 371 is habitual dealing in slaves, 372 is selling or buying of minor for prostitution, 374 is unlawful compulsory labor. Okay, 375 is now rape. Coming to the sexual offenses, anyone, what is it done? That yes, in any manner, if all of is done, that is penetration, insertion, manipulation of any part of body, or applying of mouth, and under which circumstances, either against her will, without her consent, or with consent, where she is put under the fear of death or grievous hurt, okay, or her any interested person, or she is misbelieved, as his husband, and that's why she gave the consent, or because of the unsoundness of mind or intoxication she gave the consent, then that would be, even if with consent, then still would it be rape. Now wife below 18 years, still it can be rape, and unable to communicate consent, then in that case, like in the case of a dumb person who cannot speak, then also it can be rape. So this is 375, four manners, and under these circumstances, that is 6 circumstances, it can be rape. Now exception, what are the exceptions? If it is medical procedure, for a medical procedure, then it cannot be rape, or if with his own wife, not below the 15, then that cannot be rape as well. Gynecologist using any operation or checking the genitals of a woman, that cannot be rape. Independent Thought versus Union of India says that age should be 18 years. Wife's age should be 18 years. Okay. Santosh Prasad versus State of Bihar also, you need to at least go through once. Okay. Next, what is the punishment of rape? If it is less than 16, then 376 3, 20 years to life imprisonment. Less than 12, 20 years to life imprisonment or death. Okay, this is given in the 2018 amendment. Now gang rape, if it is 16 years to less, than 376 DA, and 12 years is 376 DB. Now a question I'll put: gang rape, how many members are required to commit gang rape? You can tell me.
No witnesses, like one or more witnesses could be there. The quantity of witnesses is not taken into account. It is quality.
Witness, not witness. I'm saying how many members are required to commit gang rape?
Sir, one or more.
One or more. Okay. So I'm asking, my question is that whether a man and a woman can be considered a gang for commission of gang rape.
No, sir.
Yes, sir. They can be.
Yes, sir.
Priya Patel versus Tata Bansi.
Yes, the abatement. The woman would be charged under abater, but and the man would be charged under gang rape. Public servant, armed forces member, jail staff, hospital staff, relative, teacher or guardian, trustee or authority in position of control or dominance. If they do this, then that would be still considered aggravated form of rape. Now, a special woman, all these special kind of women, against them also, if it is done, then also it would be considered rape. That is, pregnant woman, incapable to giving consent, disabled, that is physical or mentally disabled, or now repeated rape of same woman, all this will be also coming under section 376 clause 2. Okay. Now special case, if your violence is caused in communal or sectorial field and their rape is caused, then it will be also aggravated rape, and grievous hurt or life is endangered while committing rape, then that would be also coming under 376 clause 2. Now, amendments of rape, yes, 1983, this is the Tukaram versus State of Maharashtra, where 376 ABCD were added, where the certain rape by constable was done. Now, 2013 is the Nirbhaya case, where the rape definition was widened. 375, 376, 376 ABCD were substituted, and moreover, certain other provisions were also added. 2018, 376.3 was inserted. 376 AB, D, and BB were also inserted. Okay. Now 376A, for causing death or resulting in vegetative state of victim, that is 376A. 376B, sexual intercourse by husband with woman during separation, and 376C, sexual intercourse by person in authority. 376D is gang rape. Yes, the relevant case is Priya Patel versus State of Madhya Pradesh. You'll go through that. Okay, where it is said that yes, woman cannot be charged under rape, but yes, she can be charged under gang rape. Now 376E is repeat offenders. This also you have to consider. Now 377, coming to unnatural offenses. If someone is voluntarily, okay, that means willingly has carnal intercourse, either physical, bodily, or sexual, against the order of nature, then in that case it would be coming under the unnatural offense. Nag Foundation versus Government of NCT Delhi is important case where 377 was declared unconstitutional with respect to the fact that it punishes consensual intercourse between two adults. Okay, not that any other all entire 377 is done away with, just that yes, two males or two females now can indulge in sexual activities and it will still not be considered unnatural offense. But of course, uh, other forms of unnatural offenses are still included here. And because right to privacy under article 21 is violated when he is unable to perform sexual act of his choice and when he is unable to choose sexual orientation of his choice. So Nag Foundation versus Government of NCT of Delhi. Okay. Now next is offense related to marriage. Offense related to marriage, section 493 is cohabitation by deceitful means. Now 494 is bigamy. 495 is bigamy with concealment of former marriage, and 496 is marriage without ceremony. 497 is adultery. 498 is detaining married woman. Detaining married woman. Okay. Now 493. Every man, if by deceit, any man who by deceit causes woman not lawfully married to believe that she is lawfully married and cohabits with her and has sexual intercourse with her can be punished under 493 for 10 years plus fine. Okay, 10 years plus fine. Now 494 says if whoever having husband or wife alive marries another woman, then she can be punished for 7 years plus fine. Of course, the second marriage would be considered void ab initio itself. It would be void ab initio totally. Okay. Now coming to the exception to 494, if the wife or husband, the first marriage is void, then the second marriage will not be bigamy because the first marriage is void. So the second marriage will not be considered bigamy. Now, if the husband or wife is missing for more than 7 years, then a presumption is drawn that he's presumed dead. So then, if the marriage is done by the husband or wife for the second time, that would not be considered bigamy because the presumption of death is given here. Okay. Next, 495, if he commits bigamy without informing the subsequent partner. So second person also doesn't know. First person though did not know in the first case. But here the second person to whom he married, that also he did not know about the fact of the former marriage. Then in that case, 10 years plus fine, and 496 is dishonestly or with fraudulent intention goes through marriage ceremony knowing not lawfully married, then that is also punishable with 7 years plus fine. Okay. Now 497, adultery. Joseph Sign versus Union of India says 497 is unconstitutional and it is struck down, but it is still a valid ground of divorce. 498 is whoever takes or entices, takes as in with or without force, entices is means allures, or has reason to believe knowledge to be wife of another, and he does so with in order to have sexual intercourse or conceal her or detain her, then in that case the punishment given can be 2 years plus fine. 2 years plus fine. Okay, 2 years plus fine can be given. Now 20A, cruelty of by husband or relatives of the husband. If someone is doing what, either cruelty or by willful conduct, that is instigating her to cause suicide, injury to own, or danger to physical or mental, then or causing harassment to the woman or coercing her or related person to fulfill dowry demand, then in this case the punishment that can be given is 3 years plus fine. 3 years plus fine. 3 years plus fine. Okay. So next, offenses against property: theft, extortion, robbery, dacoity, criminal misappropriation, criminal breach of trust, receiving stolen property, cheating, fraudulent deeds and disposition, mischief, and trespass. Okay. Now theft is whoever dishonestly takes any movable property out of possession, either direct or constructive, without consent. He just moves the property. Okay, without consent, that means implied or express consent, then in that case it would be theft. Okay, if I just simply cut a tree from a garden of a someone, I don't take it, but I still cut the tree, then would still be theft. Okay, punishment given is 3 years plus fine for both. 380 is if it is done in dwelling house, that is a building, tent, or vessel used as human dwelling, then in that case 7 years plus fine. And theft is done by clerk or servant, that is property in possession of master or employer, and the clerk or servant steals it, then 7 years plus fine, aggravated form of theft here. Okay, and theft for preparation for causing death, hurt, or restraint, then here rigorous imprisonment of 10 years plus fine can be given. Okay, now extortion: intentionally puts fear of injury or on or someone else and dishonestly induces him to deliver any property or valuable security, or anything signed or sealed to convert into valuable security, then in that case it would be considered extortion. What is a valuable security? That is given under section 30 of IPC, that any document by which a legal right is created, extended, transferred, restricted, extinguished, released, or acknowledged. Now punishment for extortion is 3 years plus fine or both. Putting in fear of injury or attempt to commit extortion, 385, and 386 is commits extortion, put and extortion is basically asking him to give. Now here what he's done is, suppose A went to B's house and he steals his Rado watch. Now this is theft, but here he says that I'll keep your child in wrongful confinement until you give me a check. That is under fear, you are asking him to deliver it or to give it, that is extortion. Now robbery can be both. Theft can be robbery in certain cases and extortion can be robbery in certain cases. When theft can be robbery, if in order to commit theft or committing theft, or in carrying away property or attempting to carry away property by offender, he voluntarily causes death, hurt, or wrongful restraint, or he is attempting to do so or putting in fear of doing so, then in that case it is come under the robbery. Theft becomes robbery. Now when Extortion becomes robbery when, in committing extortion, accused is present in front of the victim. Here, instant fear of death, hurt, or wrongful restraint is put either to own self or someone else, and he is induced to deliver property. Then, in that case, it will be extortion. So here you are putting pistol and is saying that you give the watch or I'll kill you. That is robbery. Now, the difference between robbery and extortion is extortion. The sense of urgency is not there. I'm calling him and saying, "See, you give it, otherwise, I will take your child." That is extortion. But if I'm putting him in instant fear of death by putting him under fear of death by putting a gun on his head, I'm asking you give the chain instantly, then that would be a robbery. Okay. Now, element of robbery is that yes, fear of instant death, grievous hurt, or wrongful restraint must be there, and thereby immediate delivery of property should be done. 392 is punishment for robbery, rigorous imprisonment or 10 years of fine, and if robbery is committed in highway or between sunset and sunrise, then 14 years it would be aggravated form of robbery. Now, immediate 393 is attempt to commit robbery, rigorous imprisonment of 7 years plus fine. Rigorous imprisonment of 7 years plus fine is there. Now, 391 Dakaiti. If 5 or more persons conjointly, that is together, what do? They commit robbery or attempt to do robbery or intentionally aid and physically present, then in that case they would be considered dakaiti. So you are committing robbery, but 5 or 4 persons conjointly are doing so, then it would be dakaiti. Okay. Now 399 is 399 is also punishing the preparation to commit dakaiti, that is with rigorous imprisonment of 10 years plus fine. Okay. So dakaiti and waging war are two offenses where preparation is also punished. Now 394, if voluntarily causing hurt in committing robbery. So while committing robbery, you are voluntarily causing a hurt, then life imprisonment or rigorous imprisonment of 10 years plus fine. And 395, if punishment for dakaiti, that is max life or minimum rigorous imprisonment of 10 years plus fine. Now 396, dakaiti with murder, then in that case death, life imprisonment or rigorous imprisonment for 10 years plus fine can be given. Now 397 is robbery plus offender uses deadly weapon to cause death or grievous hurt, or dakaiti, offender uses deadly weapon to cause death or grievous hurt, 7 years. An attempt to robbery or dakaiti while using deadly weapon, it would be 7 years as well. Okay. Now punishment for being member of gang of dacoits, section 400, life imprisonment or rigorous imprisonment of 10 years or fine, or if we are a member of gang of thieves, then 401, 7 years plus fine as well. 402, assembling for the purpose of committing dakaiti, here rigorous imprisonment of 7 years plus fine is also there. Now coming to criminal misappropriation, if there is a dishonest intention must be there, and here misappropriation or converting to own use must be there. So whoever dishonestly, what does he do? Misappropriates or converts to own use any movable property, then in that case he'll be punished with 2 years of fine or both. Okay. It doesn't matter for how much time it is taken. It is taken for some time also, then also it would be criminal misappropriation. And explanation 2 is, if found property not in possession of anyone takes for protecting it or restoring it to real owner, then if he doesn't have reasonable means to find the owner, then he will not be considered misappropriation. But if he has reasonable means of finding the owner but he still misappropriates, then it would be considered misappropriation. Now 404 is dishonest misappropriation of property possessed by deceased at the time of death. This can be 3 years plus fine, and if offender is employed as clerk or servant, then 7 years plus fine. Now 405, criminal breach of trust. Whoever being entrusted with property or dominion over property dishonestly misappropriates or converts or uses or disposes in violation or direction of law, or willfully suffers any person to do so, then in that case it would be criminal breach of trust. Okay, now here mens rea is the dishonest intention and actus is the misappropriation or converting to use. Dishonest intention, again, it can be either of it can be formal trust, as in the case of trustee and beneficiary, or handed over property to someone to take back, that is goods kept in cloak room, or in the case of temple or gurdwara where shoes you are keeping against coupons, or casually giving property to someone, that can also be covered. And punishment is, if it is done by the carrier, Ola, Uber, etc., if the carrier does so, then 407, or done by clerk or servant, 408, or by banker, merchant, agent, or public servant, that is 409. Punishment is 3 years or fine or both. Now, stolen property, with respect to stolen property, these can be done if it is transferred, then whoever is transferring it, where property which is used for theft, robbery, extortion, and misappropriation, 410. If you are receiving a stolen property, 411, that is 3 years fine or both. If dishonestly receiving property during dacoity, that is 412, that is life imprisonment, 10 years plus fine. Habitually dealing in stolen property, 413, life imprisonment, 10 years plus fine. And assisting in concealment of stolen property, that is 414. Now, cheating. Whoever by deceiving any person, that is fraudulently or dishonestly, induces him to deliver any property, or consent to retain, or intentionally induces to do or omit to do an act or omission, then in that case he can be considered guilty of cheating under 417. Punishment given is 1 year fine or both. Now, this damage or harm caused can be up to either body, mind, reputation, or property. Okay. Now, 416 is cheating by personation. If you are pretending to be someone, or knowingly or representing someone else, or either a real person or an imaginary person, if he is doing so, then that will be guilty under 416. And cheating with knowledge that wrongful loss may ensue to person whose interest offender is bound to protect by law or legal contract, then he will be liable for 3 years fine or both. 419 punishment is 3 years fine or both. Now, 420, cheating and dishonestly inducing delivery of property. Whoever cheats dishonestly or induces person, either by induces person to sign or seal to convert into valuable security, to deliver any property, or to make or alter or destroy any valuable security, then in that case he'll be punishable with 10 years plus fine. Now, fraudulent deed and disposition of property, 421, if says concealment to prevent distribution among creditors, that is 421. 422 is prevent debt being available for creditors. 423 is false or fraudulent transfer. 424 is a removal or concealment of property. Here, dishonest or fraudulent intention must be there. Okay. 425, mischief. Whoever causes with the intention or knowledge causes wrongful loss or damage to public or any person, and what does he do? He is causing destruction of property or any change in property or any situation thereof, destroys or diminishes its value or affects it injuriously, then in that case he'll be guilty of mischief. 426, punishment for mischief is 3 months fine or both. 427, when it is mischief is done with respect to property of 50 rupees and upwards, then 427. 420 is mischief to animal, that is of rupees 10 rupees or more. Mischief to cattle or animal, 429. Injury to works of irrigation, 430, and injury to public road, bridge, or river, 431. Now, obstruction to public drainage, 432, and lighthouse or sea mark, if it is causing mischief to that, then that would be 433. Now, landmark fixed by public authority, 434. Now, if you are doing by fire, explosive, or damage to any property, then 435, or by fire and explosive you are destroying a house, then 436. And if it is to a decked vessel, then it is under 437. Now, punishment over 437 by fire or explosive is given under 438. Punishment for intentionally causing mischief to running vessel, etc., then it will be with intent to commit theft, then that will be 439. And 440 is mischief committed after preparation made for causing death or hurt, that is 440. Now 441, again it is important, criminal trespass, whoever is entering into upon any property in possession of another with intention to do what? Either to commit offense or to intimidate or to insult or to annoy. These these four things he is entering. Now then if he does so, then it will be criminal trespass. 442 is if criminal trespass is done in any building, vessel or tent used for human dwelling, then there will be house trespass. 443 is lurking house trespass. If you are concealing from the owner and chuk ke enter karna, then that is 443. 444 is lurking house trespass by night, that is after sunset and before sunrise. If you are entering into a house, then that is 444 lurking house trespass. Okay. Now 445 is house breaking, that is a passage made by himself or abettor, passage not intended for human entrance, any passage which is uh, in unintended by the occupier to open, or by opening any lock, or using criminal force or assault or threat, or unfastening any passage which is fastened against entry or procedure on entry or departure, then in that case it would be house breaking. Now house breaking by night, that is if you break into house after sunset and before sunrise, that would be 446. 447 is punishment for criminal trespass, 3 months fine for 500. 440 is for house trespass, 1 year fine or both. Now house trespass punishment is 448. If you are in order to causing any offense which is punishable with death, then it is life imprisonment, rigorous imprisonment for 10 years. If you are committing house trespass in order to commit any offense punishable with life imprisonment, then under 450 it would be life imprisonment of 10 years. If you are committing house trespass in order to commit any offense which is punishable with any other forms of imprisonment, then it would be 2 years, 7 years, 2 years, and if it is for theft, then it is 7 years. Now house trespass after preparation of hurt, assault or wrongful restraint, 452 says punishable with 7 years. Now lurking house trespass or house breaking, punishment is 453, that is 2 years. Now with intention to commit offense, punishable with imprisonment, that is 454, 3 years or 3 years minimum or 10 years maximum. Now after preparation for hurt, assault or wrongful restraint, 455 says 10 years. Now causing grievous hurt, if you are committing lurking house trespass or house breaking, then life imprisonment or 10 years. Then lurking house trespass or house breaking by night, punishment is 456, 3 years. Now to commit offense punishable with imprisonment, then 457 says 5 years or 12 years, 14 years if it is for theft. Now after preparation of hurt, assault or wrongful restraint, under 458 it is punishable with 14 years. Now if it is jointly punishable with death or grievous hurt and caused by one of them, then 460 says life imprisonment or 10 years. 461 says dishonestly breaking open any receptacle containing property, सिंधु का भांगिवा, then that is 2 years. Now 462 is 461, but done by person entrusted with the custody, then that is 3 years. Now offenses relating to documents or relating to property marks. 463 says forgery, if you are dishonestly or fraudulently making any sign, seal, making any make sign or seal or alter document without lawful authority or cause any person to do so, then that would be coming under this. Here the causing damage or injury that is of public or person, or support any claim or title, cause any person to part with property or enter into the contract which is with an intention to commit fraud. If all these are done, then that is 463. 464 is making false document, 464, and 465 is for forgery, the punishment is 2 years fine or both. 466 forgery to be used in court or public register, that is 7 years plus fine. 467 okay. Now 467 is valuable security or will authority to adopt, etc. Or life imprisonment plus fine, read with 472 and 477. 468 is for cheating, that is 7 years plus fine. 469 for varying reputation, that is 3 years plus fine. 470, that is forged document or electronic record made wholly or partly by forgery, that is 470. 471 is using as genuine forged document, that will be 471. 477A is falsification of accounts, that is 477. Now, making or possessing counterfeit seal with intent to commit forgery, that is punishable under 467, and if it is done otherwise, then that is 473. Okay. Now, if valuable security or will with authority to adopt, that is 472. Counterfeiting device mark used for authenticating document in 467, that will be punishable under 475, and if it is other document, then that is 476. You just have to look through, not that important. Sometimes it may come, so just have to doubly sure. Now, defamation 499 says with an intention or knowledge or reason to believe. What are you doing? You are making or publishing what? Imputation concerning him by words spoken or to be read, by sign or by visible imputation, representation, to cause harm to reputation of person, that is lowering his moral or intellectual character, lowering character with respect to caste or calling, lowering credit worthiness, or causing to believe person in loathsome state. All these will be coming under defamation. Now the exceptions are that if it is for public good, there when it is made or published, then it will be exception. Conduct of public servant, it's okay. Public questions, public performance of merit, that is okay. Now court and lawful authority, merit of case decided, report of court proceeding, all of these is okay. Acquisition, etc. is okay. Now privileged communication, if imputation made for protection of interest or caution intended for good of person, then in that case that would also be coming under exceptions. 500 is as the punishment for defamation, which is 2 years plus fine or both. 501 says that printing or engraving matter known to be defamatory is 501. 502 sale of matter such as in 501 is 502. Coming to chapter 22, 503 criminal intimidation, that is threatening other with injury to person, reputation or property. Reputation either of own or interested person includes a dead person as well. Now with the intention to do what? Cause alarm or to omit to do, cause alarm or to do act not legally bound to do, or omit to do an act legally bound to do, then in that case it would be guilty of criminal intimidation. The punishment given is 506, and intentionally insulting to provoke breach of peace is 504. And 505 statement conducing to public mischief, if you are giving any statement to cause mutiny, disregard or duty failure by army member, or involves public to commit offense against state or public tranquility, inciting offense against class or community, promoting enmity or place of worship, if you are doing so, all of these are punishable. First four are punishable with 3 years, and the last one, if it is committed in place of worship, then that is 5 years. It has to be read with 5153A, which we have discussed. Now 507 is criminal intimidation by anonymous communication. Criminal intimidation by anonymous communication, that is 507. 508 is act caused by inducing person to believe that he will render the object either to divine displeasure, that is 508. তুমি যদি নକୁ ଯିବ ନରକକୁ ଯିବ ଏମିତିଆ କହିକି ତାକୁ କିଛି କାମ କରାଇବ, then 508. 509 ରେ କ'ଣ କହିଲା? What sound, gesture or object ଏସବୁ କରୁଛନ୍ତି କ'ଣ ପାଇଁ? With intention that what to be heard, act to be seen or intruding the privacy, then in that case it would be 509. 510 କହୁଛି misconduct in public by drunkard person, that is 510. Now last chapter 23. 511 କହିଲା ଯଦି ବି punishment for attempt to commit offense punishable with life imprisonment, ଯଦି କୋଉଠି କିଛି express provision ଦିଆ ଯାଇନି ଆଉ ସେ offense ର ଆପଣ attempt କରୁଛନ୍ତି, then life imprisonment ସହିତ ଯଦି punishable, then half of li ମାନେ କେତେ ପାଇବ? କି କହିଲେ half
10
of,
years.
yes, because for fraction it should be consider 20 years. Now, if it is for other imprisonment, then half of the longest term of imprisonment for that offense it will get. Okay, so this concludes our IPC. I will also share a slide of landmark case laws, but as these are huge, we can't discuss it. But of course, if you there are those will be self-explanatory of the case laws. I will also share the slide. This completes our discussion on Indian Penal Code. Tomorrow and day after, we will complete CPC and our marathon classes will be over. So tomorrow and day after, that is 18 and 19, will complete CPC. 2021 are holidays for not holidays for preparation of prelims, and 22 you have your prelims. Some of you, not all. And then again 23 is a Sunday, and from 24th again we'll resume our normal classes. That is from Monday we'll resume our normal classes, which will be both offline and online as well. Okay, thank you everyone, and we're ending the session here. Yes, Ashish, are you saying something?
Thank you, sir.
Okay, thank you everyone.